So last time we were in the middle of the family medical leave. We were talking about basics of the family medical leave. The fact that it gives you how many weeks, just by way of review? 12 weeks. What period? Time period? Any 12-month period, depending upon how we designate it. All right. And the purpose of that 12 weeks is for what?
Care of anyone that has some sort of major illness or surgery or something along those lines.
Okay. Care of a serious health condition, and it has to be somebody that's parent, spouse, okay, child, that type of thing. So it has to be really immediate. Interesting, by the way, let me just point this out. Funerals do not qualify under the Family Medical Leave Act. Why not?
There's usually a bereavement time off.
Well, usually there is a bereavement time that the company gives. I'm not sure. Some states may give certain laws, okay? The Family Medical Leave Act doesn't cover bereavement, all right? Because, I mean, I don't want to be crass, but it's not to care at that point, right? We're already beyond the point of needing care. So we've seen a couple of cases out there where guy leaves, takes care of, and then wants to stay for the funeral, and they say, no, we've given you enough time, you got to get back here. And wrapping things up, you know, a lot of that emotional stuff, sorry, that doesn't fall under the family medical leave. There may be other remedies, all right? But that's the nuts and bolts of the family medical leave. Now, what's that purpose for? I mean, it's not just to give leave, but the idea is to protect the job of the employee when they return to leave. So you give them leave, you give them up to 12 weeks. A couple of other things that can apply here, which I don't think we talked about, which we didn't talk about last time. You can have what we call intermittent leave. Okay? Intermittent leave. In other words, let's go back to a cancer situation. I may only, or take the pregnancy. We've been going with the pregnancy. Morning sickness, okay? If somebody has morning sickness pretty bad, then during the course, they can take leave off for that morning sickness, okay? So they don't have to take a whole day, if you will, all right? And so they periodically take the leave off. Now, when we talk about leave, that's what we call intermittent leave or reduced leave. Okay? Intermittent leave or reduced leave. By the way, a work week, and let me throw this out there, a work week is, how do we define, by way of review, how do we define work week under the Fair Labor Standards Act? Anybody remember? Any consecutive 7-day period, okay? That's the description and the definition under the family or under the Fair Labor Standards Act. The work week under the Family Medical Leave Act is generally what you work. What I mean by that is, if you generally work 40 hours, that is a work week, okay? If you generally work 30 hours, that is a work week. All right? So you don't break it down. The person who only works 30 hours a week doesn't get 40 hours of leave time. Okay? It's not based on an hourly basis. It's based on 12 work weeks, work week being what they typically work. Okay? So that's a little bit different. Okay? So if you have a person who normally works 8-hour days and they want time off, let's say they want to work a reduced leave schedule of 4 hours, okay, that would be half a day or half, you with me? Whereas a person who works less hours or more hours, that would change, okay? I don't want to get real into it, but a work week is different for the family medical leave than it is for the Fair Labor Standards Act, okay? So you get intermittent leave and you get reduced leave as well. Employers can also require you to substitute paid leave. And let me back up because I don't think we've said it yet. Family medical leave, your employer has to give you that time off. They don't have to pay you for it. Okay? Your employer doesn't have to pay you for that time off. So it's what we call unpaid leave. They have to give it to you, but they don't have to pay you while you're on it. Your employer can, however, require you to substitute paid leave. And what do we mean? What might be an example where they would require you to substitute paid leave? Amanda?
Sick time?
If you have sick time, all right. If you have paid time off, what else? Sick time, paid time off. Pardon? Yeah, no, absolutely. Vacation time. All right? If you have vacation time. I don't know if it was just because I was as managing member that it surprised me, and maybe I shouldn't have been surprised. One of the things that we always ran into when we were talking about family medical leave is we required them, at my former practice, required them to use vacation time. And they were, you know, not always, but we always had a couple of employees that were just, you know, dumbfounded that we would actually require them to use vacation time. And it's like, well, it's the law, and we're not going to give you 12 weeks to, you know, take care of yourself and then give you another 4 weeks or 12 weeks of vacation. I mean, pretty soon you can have a situation where an employee is not working at all, and that's not what the Family Medical Leave Act was designed for. So, yeah, paid leave, so you can require leave to be, or paid leave to be substituted. Okay? So how does this procedure work? What's the procedure if you want leave? Well, the first thing is the employee has to request it. Okay, so we're talking about how do you get this into motion? And we know what the Family Medical Leave Act is. We know what it provides. We know that it's unpaid leave, but you can provide substituted or require substituted paid leave. We know how that 12-month period works. All right. So how do we get it? Here's what happens. Really simple. And by the way, there are forms out there to use, and when you're in the practice out there, use the forms. Okay. You can find them on the Department of Labor's website. All right. But these forms, basically, the employee submits a form that says they want medical leave. Okay. The employee submits or requests leave. Now, they don't have to use any particular form. They don't have to say any particular magic language. If the employee says anything that would clue you into the fact that they might have a Family Medical Leave Act issue, you are required as an employer to recognize that. So they don't have to utter the magic words, I want family medical leave. If they say, hey, I want time off to take care of my husband who had a heart attack, okay? Got to give him leave. Okay? Now, the question becomes, when they give you a condition that may not be serious, and then you have to decide as an employer, is this a serious medical condition? And you have to treat situations as if they are serious and find out more information. So the employee designates, or the employee says, I want leave. It is then, and by the way, they have to do that within, if they know about it, they have to do it in advance, okay? If it's an adoption or a birth, okay, they have to say, hey, I'm getting ready to have a kid. I want time off for that, all right? If it's an emergency, they don't have to give that same notice. They could call in and say, hey, I'm here at the hospital, and that immediately triggers the leave, okay? Now, the employer then has an obligation under the law to respond to the employee and say whether they're entitled to family medical leave and how much they're going to have. Okay? So the employee requests it. The employer responds to that request. Now, How does an employer know whether or not the employee needs it?
Well, the employer knows how much they work and how long they've been there.
Okay, well, they know how much. They know whether they qualify. That's a good point, Tom. They know whether they qualify for it. So if they've been there 1 year, or I'm sorry, if they've been there 1 week, and they say I need my 12 weeks off, that's easy for the employer. Employer says no. Okay, no, that's a good point. Okay, so they know how long they've been there. How else? How else can the employer decide whether or not there's a? Well, let's take the serious health condition aspect of it. How does the employer know whether there's a serious health condition? Doctor's notes, okay? Basically, there is a form that the employer can provide to the employee. And it is the employee's obligation to get that form completed. But basically, there is a form that the employer gives the employee and says, take this to your doctor and bring it back signed in 15 days. That 15 days is not hard and fast because it can depend upon the circumstances, but generally it has to be within that 15 days. Again, it depends upon the circumstances, but generally within that 15 days. And so they go through, and the doctor gets this form, and they say, hey, does he have a serious medical condition? And they basically define serious medical condition. Is it going to be to care for somebody? And they basically say a child or a parent or a spouse or something, spell out through the law. And how long are they going to need off? Do they need full-time off, or do they need intermittent time or reduced time? When will they be able to return to work? All of that is on a form that's simply called a medical certification. Okay? They send out a medical certification. They have the right to ask that. They want to know the date that it started, the date that it'll end. Okay? Now, in addition to that, you sometimes get disagreements. Well, is this doctor qualified to give this? All right. So to give this opinion. Okay. So for instance, let me be absurd here for a second. You have somebody coming in with regard to a broken bone. All right. Or they've claimed that they've fallen, that they've broken their bone, and that they need in their ankle, and that they need, 5 weeks, whatever, to off of leave so they can take care of that condition. Because the medical condition, by the way, we haven't really talked about, can be for yourself. I mean, it can be for yourself. Let's not forget that. I kind of assume that, but it can be for yourself. All right. So the employer says, here's a medical certification. Take it to your doctor. If that employee takes it to their dermatologist, okay, a problem with that? Yeah. Okay, they can go, nah, we're not gonna require that. So the employer can require a second certification. Okay, the employer, and we're not going to get into all the nitty-gritty details because it gets pretty complex at that point, but there can be up to a third medical certification. There can be up to a third medical certification. Now, after the employee brings back that certification, then at that point, the employer has to say, we're going to give you leave, or we're not going to give you leave. Here's how much leave you have, and spell it out. Okay. Any questions on that procedure? Yeah, I mean.
Well, I just have a question. It kind of goes back to the serious injury. If it's for yourself, and say it's not a serious injury, say it's cosmetic surgery. Because the definition, it would have to be an injury or an illness.
Yeah, I would say under that definition, it probably it's not an injury, it's not an illness. Let me make sure. I want to look at the exact definition, but I don't think you get that. I've not been asked that. It has to be a serious condition. You know, here's the actual definition. It's an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment. I could argue, but I don't think that's a purpose of the act. I don't think that's the purpose of the act. And I'm not saying that's a great question, and I don't know the answer to that. I don't know. I'm going to look that up because now I'm curious. But my gut tells me it's not really a physical. It becomes a physical condition, but it's not a physical condition. You see what I'm saying? Unless it was cosmetic surgery as a result of a physical. I would say you're not getting treatment for a physical condition. Now, those who may have cosmetic surgery may disagree with me. I don't know. But I would say that's not a serious health condition. That's a good question. Okay? Other questions? Okay. All right. So there you get the idea. Any other questions on the family medical leave? The only other thing that with that is employers can require fitness for a return to work or fitness for certifications for fitness. Okay. Return to duty certifications, whatever you want to call them. They can require those. Now, if they're going to require them, they really need to require them all the time. They can't just require it for somebody who's gone out on family medical leave. Couple of acts. The Family Medical Leave Act is enforced by the Department of Labor. It is enforced by the Department of Labor. And it is illegal to interfere with or discriminate or retaliate against someone who is trying to exercise their leave rights or who has exercised their leave rights. And a couple of cases in the works, and I had to leave them when I left private practice. Same employer, different employees. One took off for pregnancy. The other one had some kind of physical condition, required hospitalization. These take off at separate times. I mean, they're completely not related in any way, except they work for the same employer. And I won't mention who the employer was. But in both situations, they came back to work. And before they came back to work, they called and said, I'm getting ready to come back to work. The employer says, fine, before you come back to work, you have to give me a fitness that you're able to return to work. Now, one of them I was talking to while she had gone to work, come back to work, and they said, no, you got to give us your fitness for duty. I said, go get it. They tell you to go get it. Go get it. Bring it back to them. Don't worry about it. Hopefully everything will be fine. You don't need to talk to me again. In both situations, they go back, they get their fitness for certification, they bring it in, and they are fired the exact same day. Okay? Now, both times they say, well, while you were gone, we found reasons to fire you. And maybe they did, maybe they didn't. I don't know what's going to happen to those cases. I don't know where they ended up. They probably will be settled. But we found it a little ironic that the same employer, why require the fitness to return to duty if you're going to turn around and fire them for something that you think they'd already done? Now, so in those situations, we don't know. I think they probably had a pretty good Family Medical Leave Act against their employer, but we'll see. Now, somebody asked me, well, what happens if you do engage in misconduct, okay, or you're involved in gross misconduct? Does that matter? Well, remember, people can give you the right to leave, okay, but the question becomes when you return. And if they were going to fire you anyway, they don't have to put you back, okay? The leave itself, it's just you've got to give that leave, but you were going to fire them, okay, that just means you're not putting them back to work. And if they committed gross misconduct, you don't have to put them back to work. first case I ever had of this was a case involving, and we won't say the employer, I think it was confidential, but a gal literally was cutting her face. She had some severe emotional issues, was cutting her face. Her husband, she calls her husband, he leaves, and they terminate him. And we go, nah, you can't do that. The act was fairly new at that time. I mean, it had come out, and when so it was a fairly new act, and we were one of the first to file a case under it, but and eventually we were able to get it resolved. But you can't interfere and you can't discriminate against somebody who exercises their leave. If you do, you're not only going to pay them their wages, okay? If it's in bad faith, you're going to pay them twice what they've lost. So if somebody's lost $1,000, but you've in bad faith not restored them back to work, now you're going to pay them $2,000. But the real kicker is you're going to pay them attorney fees. And attorney fees can add up in those kind of cases pretty quickly. All right. Any questions? Any questions about the Family Medical Leave Act? Probably more than you wanted to know. Believe me, not nearly as much as you could know. Yeah, Jackie.
I just had a quick comment because I was curious and looked it up.
Okay.
The Department of Labor website looks like it lumps things like, well, it says generally things like cosmetic surgery, colds, headaches, and routine medical and dental care are not included.
Okay.
So it seems like it just kind of
Would
all that together.
and exit and right. I don't see cosmetic as being a cold. I mean, to me, it's even less than a cold. But it makes sense that they would say it's not covered. And I think the reason they'll say it's not covered is, it's elective, and you don't have to have it. It's not to take care of a physical condition. Well, yeah, it is, but not really. So now, having said that, and you're absolutely right, colds generally aren't. One of the big cases out of St. Louis, I think, is in fact a situation where it was a cold, but it got just a real deep cold, and it became worse and worse. So while generally stomach flu, it may have been a stomach flu instead, but while those are generally not covered, if they're bad enough, they can be covered. So you can have a cold that could be covered, but you're right. For the most part, it's not going to be covered. And thank you for the cosmetic, because, I just couldn't see it being covered, but I'd never looked at that issue, never had that case. Okay? All right. Any other questions about that? Okay. Switch horses now while we still have a little bit of time left in this period and talk about military leave. All right. And this is a little bit different. By the way, we're switching horses because under the Family Medical Leave Act, you have military leave for certain active duty things. If somebody's getting deployed, you can use family medical leave, even though it's not a serious health condition, to help somebody deploy. Okay, it just has been lumped under the family medical leave. Okay, now it also has that 26-week provision that we talked about, that if somebody's injured while deployed, you can get up to 26 weeks to take care of them. Okay, we're going to switch gears a little bit, still talking about leave or reinstatement, but talk about a law called the Uniformed Services Employment and Reemployment Rights Act. And I'll give that to you again. It is the Uniformed Services Employment and Reemployment Rights Act. Okay. It is an act which basically, we won't spend a lot of time on it, but it is an act which basically provides job and benefit protections for employees who take leave of absences to fulfill certain military service obligations. And I'll give that to you again. Okay. The Uniformed Services Employment and Reemployment Rights Act is basically a job and benefits protection for employees who take leave in order to fulfill military service obligations. It applies to all employers, regardless of size, By the way, while I'm thinking about it, Family Medical Leave Act applies to public employers as well. Okay. Same thing here. The Uniform Services Employment Reemployment Act applies to all employers regardless of size. Okay, so you don't have your 50 limit like you do on the Family Medical Leave Act. Can be National Guard, full-time National Guard duty. Okay. Can be spending time for funeral honors, somebody who goes and does a military service. Okay. Can be spent in the national disaster medical system. Basically, employees are protected if they're performing on a voluntary or involuntary basis in a uniformed service, active duty, inactive, active duty training. Okay. If it's related to the military, you probably better look really careful before you decide not to comply with this act. It extends to employees whether they are full-time, part-time, probational, or seasonal. It extends to temporary employees unless they have no realistic expectation of ongoing employment. And it also generally extends to laid off employees or even those on strike if they would generally be called back anyway. Now, in order to get this leave, the employee must generally give notice of their leave, of their military service. And it doesn't have to be written notice, could be verbal notice, but employee must generally give their employer advance notice. Now, you can have circumstances where you can't give notice. Why might you have a circumstance where you wouldn't give notice or couldn't give notice? Natural disaster, okay. Maybe some kind of secret covert operation, I suppose, that,
Terrorist attack.
yeah, terrorist attack. Something happens but so for the most part, you have to give notice. Now, basically this law says, hey, if you're taking off time to serve in the military, then when you come back, we have to reinstate you to your regular job, full benefits if we can, all right? And really more than that, if we got to reinstate you, all right? It's going to depend upon how long they're gone. And I'll just give you this breakdown because it gets a little complicated. If their service, and I'm talking the military service, is 30 days or less, okay? Then the employee must report back to the employer no later than the next work period following the end of service plus 8 hours. Okay. So if I'm leaving for military service and that service is 30 days or less, then I have to report back basically within 8 hours after the service ends, unless it's through no fault of my own. Okay. Basically, the idea is you don't want somebody taking off for a period of time, 30 days or less, and then showing up 2 months later and demanding their job back. Okay. So if it's 30 days or less, they basically have 8 hours after the beginning of the next work period. So they really get one more day, if you will, and then they have to report. If the service is 31 to 180 days, then they have to apply for reemployment within 14 days of of completing their service. So if it's 31 to 180, then they basically have to reapply within 14 days. If it is 181 days or more, if their service is 181 days or more, then they basically have 90 days to reapply. I'm not going to get into the specific deadlines and exceptions there, but there are additional exceptions if they are injured. Okay? And so, let's say they're on that service, they're injured, and they couldn't report within the 90 days. There may be an extensions time, but I'm not going to get into the details of those. Okay. Basically, there are some exceptions to that. If you're dishonorably discharged from military service, okay? So you go to military service, you're working at a job, you take leave for military service, and while you're on military service, you steal, okay? And as a result of stealing, you are dishonorably discharged. You don't have the right to be reinstated. Okay? So all of these exceptions really deal with that. If you're court-martialed, now, there is also a situation where an employer does not have to put somebody back to work if it is simply unreasonable or would create a hardship for them to do so. So, for instance, if the employer's circumstances have changed, or it would create a hardship for them to do so. Now, all of these cases are fact dependent. Okay, so whether it's going to create a hardship is going to be fact dependent. But let's take an easy situation. You have somebody who is employed in Louisiana, all right, and they leave to go on military service. And while they're in military service, Hurricane Katrina comes by and takes out a large part of New Orleans. And with that, doesn't completely destroy a business, but takes an employer from 50 employees to 2. Okay, I can almost guarantee you in that particular situation, the court's going to say you don't have to put him back. Okay, you've had a situation here, an unreasonable situation. Okay, now we can draw up whatever scenarios we want. They're going to be fact intensive, but if it's truly unreasonable for the employer to put him back, then the employer may not have to put him back. Okay. Any questions about that? It's really job protection for those who take a leave for military service.